Hello, today we are going to be talking about legislation and the drafting of legislation in the UK. Joining me in this discussion is Elizabeth Gardiner, who's none other than the first Parliamentary Counsel. But before we get into the work of the Office of the Parliamentary Counsel, I would like to give a bit of background information on our guest today. Elizabeth qualified as a solicitor firstly in Scotland and then in England and Wales. Since 1991, she's worked in the UK Civil Service as a legislative drafter called a Parliamentary Counsel, which is in the Office of the Parliamentary Counsel, part of the Cabinet Office. She has worked on a full range of legislative projects, which have included drafting pensions legislation, and for 5 years, she was the lead drafter on the annual finance bill. In 2015, Elizabeth was appointed as first Parliamentary Counsel, and she is the first woman to hold that position in its 150-year history. She leads the government in the Parliament Group in the Cabinet Office, which consists of the Office of the Parliamentary Counsel and the offices of the business managers. These are the Chief Whip and the leader in each House of Parliament. The group works with teams across government to prepare and deliver the government's legislative programme and other parliamentary business. Elizabeth, thank you so much for joining us today.
Delighted to be here.
Great. So to start off, would you mind giving us an overview of what the Office of the Parliamentary Counsel is?
Certainly, I can do that. If you were like me, I didn't actually ever give any thought to who drafted the legislation for the country. And so when I stumbled across our office, it was completely by accident. I'd never even heard of it. So the Office of the Parliamentary Counsel consists of around 50 lawyers, both barristers and solicitors, who draft the government's primary legislation. So this is for the UK government, and they draft the bills that go into Parliament. They do some other things which I'll come to, but that's their main task. In the UK, because we have devolved government in Scotland, Wales and Northern Ireland, each of those areas also has its own drafting office. So there is somebody equivalent to me and a team of people like I have here in London, in Edinburgh and Cardiff and in Belfast, drafting for their devolved legislatures. But we just work for the UK government and we produce all of their primary legislation. So my team are specialist drafters. They don't specialise in any particular area of the law, subject to something I'll come to in a minute. Their specialism is legislative drafting. So we tend to take people when they've qualified in private practice or in a public authority, they've worked for a little while, honing their skills as a lawyer, and then we'll bring them into the Parliamentary Counsel office, and then we'll hone their skills as legislative drafters. And one of the things that people like about working in the legislative drafting office is that you're working on lots of different areas of law. So you could be doing a bill for the Home Office, a crime and justice bill, 1 year, and the following year you might be working for the Department for Education and doing stuff on universities, say. And if you're a lawyer who loves the law, that's a great job to have, because you could become very expert for a year or maybe a couple of years in one area and legislate for that, and then you can move on and start from scratch on a completely different area and get up to speed with that, which is a really interesting aspect of the job. The one area where we do specialise a bit more is on the finance bill. As Rudy said, I led the finance bill for 5 years, and it's not unusual for people working on the finance bill to work on it for several years, and that's because the process in Parliament is different for a finance bill, and the sort of statute book, our tax statute book, is absolutely huge. And you really don't get to grips with it in a short period of time, and you can give back much better value to the office after a few years when you really understand how that part of the statute book fits together. So we tend to keep people there for a bit longer. So do you want me to say a little bit about how we come to draft the bills? How
I really want to know that. That was going to be my next question. But I was kind of curious, first of all, to ask you, what kind of skills do you look for or are expected of somebody who is parliamentary counsel?
Yeah, so we've honed this a bit over the years, and I think we're actually much better at it now. I think it was a little trial and error many years ago, and people tended to come into the office, and quite a few of them moved on to do other things. They were great lawyers, but they didn't necessarily enjoy legislative drafting, because it is a very particular skill for a lawyer, and you get many brilliant lawyers who can't draft, and I'm sure we would be the first to admit we might be good drafters, but we might not be great at other aspects of the law. So when we're recruiting, we're looking for people with strong academic backgrounds. One of the things that appealed to me about the job, that it is a combination of a sort of academic job with a really practical product at the end of the day. So it's a nice combination. We put people through a critical reasoning test before we interview, to sort of sift out the numbers, really, because we get a lot of applications. And then we do a test which is aimed at testing people's powers of analysis, really, because we don't expect people to come in with drafting skills. So although we do sometimes get people with some form of legislative drafting experience, that's not really what we're looking for. We're looking for the potential, the people we can train. So we're looking for people with very sharp powers of analysis who can really get to grips with things, see how they fit together, see how they're taken apart, and really think about how they could create a new structure. Because the thing about the law is, it's all very well to be destructive in your analysis, but you've also got to be able to create something. So you can't just pull apart the instructions that you're given and hand them back in pieces. You've got to give your client some ability to draft some other structure that will work. And so it's quite a creative job as well. So we're looking for creativity, but analysis. I think those are the really strong skills, but also it's a team sport. So you have to be able to work in a team, collaborate. You also have to be able to take feedback. So one of the ways that we think that the legislation is strongest is if we try and work in pairs on legislation. And so we're always giving each other feedback, and we could do that quite robustly. You know, we don't really have time to sort of pussyfoot around. So we will say to people, no, that doesn't work. This is why we think it doesn't work. Let's have a discussion about it. And people have got to be able to take that and just see it as, a proper part of the job and a really helpful part of the job, that somebody is helping you to get something right, rather than, worry about offending each other, I think.
So what is the process then? So that would be a good time to move into that. So how do we get to that point where we have an idea in Parliament or in one of the government departments, and then to the final product?
Mm-hmm. So we work for the government. So in other jurisdictions, not in the UK, but in other parts of the world, I know that the people who do our job often sit in the Parliament and draft for the Parliament, but that isn't our job. We are part of the civil service and we work for the government. So our instructions will always come from a government department, from a policy department. Bills can come about in many different ways. So, the government may have come into power on its manifesto and have committed to legislating in a particular area, and that might result in a bill. There might be a particular issue that has come out of a public inquiry, or they might have done a consultation and identified areas for reform that might produce a bill. There might be some crisis or emergency that they're having to react to, and that might produce the need for legislation. So there are lots of different ways that the need for a bill might arise. In the UK system, there's obviously a limited capacity in Parliament to deal with legislation, so there has to be a sort of bidding process and a whittling out of to ensure that they prioritise bills.
Oh, sorry, your camera's just cut off, and the sound as well. Hello.
Sorry, I just lost
you're back. You're back.
Apologies for that.
No problem. So we're in Parliament and we're whittling down the
yes. So
proposals.
Yes, so the programme will be put together for any particular session of Parliament in accordance with the government's priorities, and then departments will be commissioned to work up the instructions for Parliamentary Counsel. So the policy officials in the department will work through their policy, and then they will come to us. Well, they'll first of all go to their lawyers, and they'll discuss with their lawyers whether their policy requires any changes to the law, and if it does, they will agree between them what those changes they think are, and they will prepare written instructions which will come to Parliamentary Counsel. In fact, the process is not really as linear as that sounds, because very often we'll be involved right from the beginning in discussing their proposals and how we think that might translate into legislation, and how what they're proposing might be met in Parliament. So, we have a lot of experience of how bills are handled in Parliament and the way that Parliament expects things to be presented. So, for example, one of the areas that's quite contentious in the UK at the moment is the degree to which the government is putting in delegated powers in its legislation, asking for ministers to be given powers to make legislative instruments after the bill is passed. And so we'll be discussing with the departments the degree to which their proposals involve delegated powers and the likely reception of those powers in Parliament, the breadth of the powers and the sorts of precautions that attach to them. So the instructions come to us. We will then obviously read them and probably read them again and again. They may not be completed initially. They will inevitably need a lot of teasing out of exactly what is required. And I would say that 80% of the job is that analysis of the instructions and working with the department to come up with a robust arrangement for the bill, as opposed to sitting putting words on the page, which is what I think people imagine is what we spend most of the time doing. Really, most of the time we're thinking, we're testing out different approaches, we're looking for gaps, for loopholes, for duplication, for things that don't fit with the rest of the legislative landscape. And we're trying to build that up with the department to create something robust. And it's quite surprising, given how much work is done, good work is done in the department before the policy reaches us, how often, not the whole policy, but limbs of the policy will just sort of collapse when they're actually prodded and put under that analysis, and how we'll have to help the department rebuild something that actually is robust and fits with the rest of the legislative landscape. And that is the real sort of value added, I think, for our drafters, and that's what they can contribute to the process, because these statutes are going to be on the statute book hopefully for years to come. They have to work, and they have to anticipate future changes, and so we have to be thinking about that and trying to make the product as robust as it can possibly be. And that could take weeks, possibly, for an emergency bill that has to go in quickly, or that process might take months on a very big programme bill.
And how do you do that, can I ask? Like, how do you ensure that legislation is robustly tested and that all of the parts of it work together and interact with other existing legislation?
So, I mean, that is part of the skill of the parliamentary drafter, because one of the things we need them to be able to do is to get up to speed on a topic, an area of law, very, very quickly. They will also understand from all the other work they've done a lot of the rest of the statute book. But they're working with government lawyers for whom this policy area is their bread and butter. And so we also rely on them to understand their area of the law and to flag up things that they might know about, that we might not know about, decided cases, or bits of legislation having been interpreted in a way that might not be obvious from just reading the black and white letter law. So part of the skill is doing that, is understanding how you would then interrogate the rest of the statute book to see how it would fit in, the sorts of things that you might be looking for that might trip it up, the sorts of things you might have to change to make it all fit together. So that is part of the the skill of being the drafter. The best legislation is where all the parties are really engaged in it. So if, as a legislative drafter, you produce a first draft of something and you send it to your client and they say, "That's lovely, thank you," you just think, "Oh dear, did you not read it?" Because it's very rarely lovely at a first draft. In fact, the 4 or 5 drafts in, it may not look anything like the first draft. The first draft might be just there to tease out the issues, to really expose some of the problems, or really trying to highlight, if you do it like that, this is how it's going to look. Surely that's not what you want. And so what you really want is a client who really interrogates it and writes back to you, quizzing you about all of it, criticising it, suggesting alternatives, saying why it doesn't work. And it's through that process of back and forward that you get a really robust product. And then within the office, we try and, as I say, work in those pairs, always testing each other's work. When a bill is almost ready to go into Parliament, we put it before a panel of our peers within the office who all read it, and then you go and present yourself to the panel, and they will interrogate you on your bill and ask about it and suggest that there are areas that are confusing or not very clear or wrong, and you've got to either justify it or at least think about what they're saying and possibly go off and change bits and pieces. And then obviously you get into Parliament, and Parliament will also scrutinise your material, and you should be listening to what they're saying. What you often find in Parliament is that one criticism of the bill, even if you think, oh, that's not, I actually don't agree with that, will often take you to look again at the provision, and you will realise that something else is not quite right with it, and possibly that's why the initial criticism's been made. And so it's always good to listen to what they're saying in Parliament as your bill is going through.
As Parliamentary Counsel, then, do you have to be very open to criticism? Because I imagine as creators of something, there are so many opportunities for your work to be criticised, because, as you say, the legislation goes to Parliament where it could be changed, and then if it's adopted as an act, then it goes to courts, which may interpret that legislation in different ways, may criticise it. How do you deal with that?
So I think you have to be quite thick-skinned, but at the same time you have to be open to the criticism, because if you just assume everybody's wrong and you're right, you're going to fail, because in fact often the criticisms people make of things are worth listening to, particularly in Parliament. And obviously once the thing's enacted, we can only listen to those criticisms to inform better drafting in future. We can't go back and revisit the last, but we are interested in court cases on our legislation. So, we have a good system of know-how in the office, and we will share those cases where we find them and learn from them. And, sometimes we don't agree with the way a court has interpreted a provision. And then it is a fact that it has been interpreted like that. So we have to think about that and think about whether it has any implications for the way we go forward. So if we're using a particular drafting approach and the court is not understanding, you can't just sit here and say, well, the court's wrong. Well, the court clearly thinks that's what it means, and therefore we've got to think about what the implications for that are. And if we carry on using that approach, is the court going to continue to misinterpret it in our view? Well, in that case, we should be doing something else to make it clearer. So we're always interested in that. A lot of the criticism when bills are going through, although there'll be a lot of stuff out there saying that it's badly drafted, usually that's not really what it means. It really means we don't like the policy. So you've got to just get quite thick-skinned to that. You may not like the policy, but there may not be actually anything wrong with the drafting, and that is often what people are complaining about, is really the policy rather than the drafting. So yeah, it's a proverbial problem, but you just get used to it, I think. But I think the main thing is not to become closed to it because it's prevalent, I think, because there'll always be a little nugget in there that you need to be listening to.
Have you got any specific examples that you could share with me? Where you've been personally responsible for legislation that had just...
Well, I was described as the Darth Vader of Parliamentary Counsel. I'm not quite sure what that meant in the House of Lords once by their lordships. One of their lordships told me that those interested in grammar would be rolling in their graves because I had started a sentence with the word "and." And he didn't like that at all, but I stick by it. And I think there are circumstances in which you can start a sentence with the word "and." So those sorts of things sometimes get their lordships quite excited. But I have had other cases where I've spotted something in the House which has just been wrong, and it's amazing how often you can read your own bill and months later read it again and see something that you can't believe that you didn't spot the first time. When bills in the UK are printed, they're printed on green paper, and there's something about them appearing on that green paper that throws up all sorts of things that you couldn't spot when you were reading them on the white paper before you handed them in. So you can never read it too often. And always got to be sort of reading it with a critical eye to try and sort of flush out these things.
And how then are decisions taken in the office about the language style that you're going to use in legislation? You know, like taking this, like different types of legislation, like the Sexual Offences Act, for example, which would use very simplistic language, and then other pieces of legislation where the language would be more complex, more legalistic. Like, how do you make those decisions?
Yeah. So the UK is unusual amongst drafting officers, certainly in the Commonwealth, where a lot of drafting officers have drafting office manuals, which are quite prescriptive about how the drafters are to approach their task. The UK has never gone down that road, and one of the things that we've always valued as an office of professional drafters is that we were sort of trusted to use our professionalism. And one of the advantages of that is that you're always moving things on, so things don't get sort of stultified by always repeating the precedent, and then there has to be some sort of big powwow to get the precedent to move on. But in fact, individual drafters within reason have an ability to try new things, and you know, and that's what pushes the drafting process on. So an example would be the annual finance bill used to have well, every bill, in fact, used to have a repeal schedule at the back of it, which listed all the repeals, so all the provisions being repealed by the bill. And it was literally just an editor's guide, textual amendment, a process of textual amendment. So rather than having a whole load of freestanding bills, very often if there's an existing act on the statute we've got a subject, the new act will just amend that existing act, so you have one consolidated text. And really that's a sort of movement over the last 40 years that we've done that. Previous to that, we would have had lots of freestanding pieces of legislation. But once we moved to that, having this sort of list of repeals made very little sense at all. Yet we'd carried on doing it for years because you needed to have all the amendments, not just the repeals, so that you could understand what was happening. So, you know, everybody did it because everybody did it. And then suddenly somebody said, I'm not going to do that this time. And surprise, surprise, everybody else thought, I wonder why we keep doing that. Yes, let's all stop doing it. So, you know, you rarely would see a repeal schedule now. I mean, you'd have to have a very good reason for having one, because it's just not a useful tool. So lots of things have moved on. When we rewrote the direct taxes legislation with a massive project with the Inland Revenue in sort of 2000 to 2012, around that period. It took a long time. That really moved on drafting style. So a lot of thought went into how they were going to approach that project. And there was a real move to think much more about the structure, to think a lot more about using shorter sentences, and those sorts of things. And that has really permeated the rest of the drafting in the office. So if you compare what we're producing now to what we were producing 40 years ago, there's really no comparison at all. It's much more in everyday language. Although we don't have a manual, we do have what we call our Parliamentary Council drafting guidance, which is on the internet. And that's designed to help drafters and to ensure there's a certain level of consistency in the office. So there's two things. You don't want drafters to spend a lot of time reinventing a wheel that's already been gone round by many people before. And so trying to reduce that. But we also want a degree of consistency across our legislation, because if we're actually meaning the same thing in two places, then it would be quite helpful if we approached it in the same way. And then there are various sort of drafting issues that come up where we just want people to make sure they go through the right thought process. They might not produce the same drafting, but they need to have gone through the same thought process to make sure that all the bases are covered. So our guidance is incredibly useful for that. And that has helped us, I think, maintain a consistent product. In terms of the language, so we're always thinking about how we can make the legislation as clear as possible and as accessible as possible. We've got lots of different audiences, so we've got to think about the parliamentarians in Parliament, and we've got to think about the courts, and we've got to think about the end users. And the reality is that a schedule on the taxation of controlled foreign companies is not going to be read by the man on the Clapham omnibus, so it does not need to be written like that. It would be much more helpful if it was written using technical terms used by those who operate controlled foreign companies. And so that's part, sometimes we're using terms of art because that is actually most useful to the people who are using that legislation. Sometimes we're aware that the legislation is very much going to be read by the public, possibly by professionals other than lawyers in their jobs, so people like school governors or health and safety officers or those sorts of things, or sometimes just by the general public. So lots of coronavirus legislation just now is being consulted directly by the public who are trying to see what the restrictions are that apply to them. And so we have to have that in mind when we're thinking about the language that we use, and trying to make it as accessible as possible for those people. But it's always a balance, because you've got so many competing things to be thinking about, because we have a huge existing statute book, and if you suddenly drop a piece of legislation in the middle of that which connects to lots of other pieces of legislation, there may be a real advantage to continuing with the language register that's used in all of the existing legislation, which has been tested in court, which people understand what it means. And if you suddenly depart from it now, that's going to be a problem. So that's sometimes a restriction. In everyday writing, you can emphasize things by repeating them in slightly different terms, whereas you can't do that in legislation, because if you use different terms, people think you mean something different, or quite rightly they should. So you haven't got those same techniques when you're drafting legislation. So there's lots of sort of competing considerations, but the skill of the drafter is trying to come up with something that's clear and accessible and coherent within the confines that they're working in. And one of those confines is time. In time to, if I had longer, I'd write a shorter letter, type of thing.
And at what stage in the drafting process do you identify the end user?
I think you know that right from, well, you're thinking about it right from the beginning, because when you get your instructions in, you excuse me, you understand. They will set out the whole of the legislative regime and why they're doing this, and so you'll have a fairly clear idea from the beginning, who the primary users of the legislation are likely to be.
And is there any kind of a mechanism for the post-adoption review or feedback from users about the extent to which a statute does what it was intended to do?
Yes. So there is a system of post-legislative review in the UK Parliament, and after a statute has been on the statute book for a certain period of time, the government submits to Parliament a memorandum about the operation of that legislation. And this came out of a Law Commission report. So we have a law reform and consolidation body which sits in our Ministry of Justice, and they produced a report recommending a system of post-legislative scrutiny. And this was adopted. I have to say, it is not working, I think, in the way that they necessarily anticipated it might. And there's a lot of discussion about it, and it comes up from time to time in Parliament, because the reality is that politics and the political landscape is moving so fast that by the time you produce your report on your bill, really the political focus is elsewhere. They've moved on to the next piece of legislation, the next policy area that's being reformed or needs attention. And so the committees in Parliament are not necessarily wanting to spend their time discussing a review of a piece of legislation that was enacted, possibly under another government, possibly is about to be reformed, possibly not. I mean, they just maybe don't want to go back there and look at that. They would rather look at something that is very current. So getting a lot of attention on these memoranda has not been easy. And one or two of them have been taken up by committees, but most of them have not. So it is that system, I think it has got potential, but it's maybe not operating at its full potential at the moment. As an office, we obviously keep a lookout for cases where the legislation is being challenged or being interpreted, to see what the courts make of it. And departmental lawyers will be using those statutes often in anger, and so we may get feedback from them where things have not turned out. And in the very worst cases, we'll be being instructed on emergency bills or new provisions to fix something that has potentially gone wrong in a previous piece of legislation. And so it's always, you need to be thinking about that and trying to pick those up. But as an office, we're sort of thinking about where we want to be in 3 years' time, 5 years' time, and we're developing that strategy at the moment. And one of the things that we want to focus on a bit more is trying to get more feedback from users, because often the feedback that comes back is more about the policy, the operation of the policy, rather than actually whether the drafting has gone wrong. And so we're looking at ways that we might be able to capture more of that information about the drafting going forward, rather than just about policy. So I think it is an important area, and we probably don't hear as much as we should about things that people haven't found easy to operate in practice. Twitter is also a good source, of course. I do see on Twitter the odd what on earth was the drafter doing here type of comment. So
yeah, I've noticed that legal academics have become very active on Twitter as a way of quickly presenting to the world short, sharp arguments on all kinds of topics. So where then does the office have a right of initiative when it comes to post-adoption review? Like, can you, if you're keeping an eye on Twitter and case law and you see that there are problems with the language, what can you do with that?
No, so we wouldn't have an initiative. So occasionally somebody will come to me and say there is an issue with something, and what I will do is I will pass that on to the relevant policy department to consider and see whether they think it's something that needs addressing. But no, the office wouldn't take any initiative there in terms of, other than passing it on to the relevant responsible department.
Okay. So then I want to come back to something that you said at the beginning about the fact that there are drafters for each of the devolved administration or legislatures as well as in London. So how do you maintain consistency in legislation to make sure, not just in your office, but also in Belfast, Edinburgh, Cardiff, that the legislation drafted there is of the same language? Does it have to be of the same language or the same terms used?
So I don't think it does have to be. I mean, obviously in Scotland they have in large part a different legal system. Some of the legislation areas are reserved, and they will be legislated from the UK Parliament. So we may be producing, say, tax law, which is the same, although increasingly not the same, but traditionally was the same all over the country. But because there's a separate legal system in Scotland, in large part their legislation has been very different anyway. The reality is that we do draft in a fairly similar way. The heads of the 4 offices get together on a fairly regular basis to discuss issues of common interest, of which there are many, and that from training our drafters to sort of initiatives like trying to improve the quality of the legislation, or the quality of the instructions that come into us, and all those sorts of things are common to us. But there are different issues in different parliaments. So the Scottish Parliament, the Scottish drafters, there was always a Scottish drafting office even before devolution, and those drafters were based in London, and they drafted the Scottish bills that went into the UK Parliament. And so that drafting office moved to Edinburgh. We have a member of that office who effectively works for the UK government, and there's Chinese walls there to enable them to draft those Scottish provisions still that are in UK bills, which there are quite a number, either because it's reserved or because the Scottish government and Parliament accept that we will legislate for them on a particular issue, and they will agree to that. So that's in relation to Scotland, and that's because in large part the legal system is so different. So be it the criminal law or the land law is so different that we definitely need that assistance when we're producing the bills for the UK. Wales didn't have a drafting office originally, and it had to be set up from scratch post-devolution, and our office in the UK provided some help initially to get that up and running. But that is now a fully formed office, and they have the added interest, perhaps, or challenge of having bilingual legislation. So they're producing Welsh and English legislation. So that is quite a challenge that they have. And but they don't have, and their legislative programme is a lot smaller, a smaller jurisdiction. Their sort of main legislative programme is a lot smaller. But they've recently passed a Legislation Wales Act, which has various duties in relation to sort of improving the quality of the law and publishing it. And that office is heavily involved in that. And then the Northern Ireland, again, because of the history of the Northern Ireland legislature, they have also always had a legislative drafting office in Belfast, and that continues to serve the executive there. So I don't think we draft in wildly different ways, but at the same time, each jurisdiction's, has a sort of is proud to produce the legislation for that jurisdiction, and particularly perhaps in the newer legislatures, they would want to sort of strike out and make their own mark in the way that they want to produce their legislation. But theirs evolved just like ours has evolved. I mean, it's not a static thing at all. As I say, the sort of style and approach on legislation has changed, dramatically. Might be, I don't think anything in legislative drafting happens dramatically, really, but there has certainly been a very stark evolution of the drafting process over a few years. And it's quite, you'll see it on Twitter and elsewhere, where people will say, oh, I'm trying to find out what the law is. And then I thought, I'll just read the law. And well, surprisingly enough, I actually managed to read it and I understood what it meant. And sometimes our frustration is that people sort of assume they won't be able to understand it if they read it. And often we think, just read it, because in fact you might find it more accessible than you think you will. Because people tend to grasp for textbooks or guidance or publications from the government explaining the law, whereas sometimes it might be better just to go and read the law.
Are there any very well-known examples where there are distinctions between devolved acts and the methods of drafting legislation that your office would use? Not really. I'm not aware of really sort of stark differences. No. So does it ever happen whenever the four first consuls get together and then one of you says, oh my God, I can't believe that you put that into a piece of legislation. I would never have put that. What were you thinking?
Certainly not. No. I mean, we do discuss, things in each other's bills. If, sometimes we are aware of things, but to be honest, I think each of us is pretty busy in our own jurisdiction. And we have to watch in the reserve territory of sort of getting under each other's feet and making sure that we're all joined together, or where we're legislating for other areas, even where it's not devolved. But most of the time, these things exist sort of separately, because the whole point of devolution is that their policy can depart from the UK's policy, and if there is devolved, they may wish to legislate to provide a different outcome. So we wouldn't necessarily be crawling all over it to see what that outcome was. I think the big thing is just making sure that we, that we tie everything together. So sometimes we have a statute which originally was UK-wide. So, for example, there was recently legislation on civil partnerships, and England was doing legislation, Scotland was doing legislation, and now Northern Ireland has done legislation, and just trying to make sure that what we were left with worked, and any cross-border issues, which inevitably there are with something like civil partnerships, worked properly, and that we didn't end up dropping anybody sort of down on the border by mistake in terms of the policy outcomes. So we have very close relationship with all the offices in the UK and the drafters as well. So it's always possible just to pick up the phone to somebody and talk through an issue and see whether there's a problem or whether we need to do something to address an issue. So so far so good. It's worked all right, I think.
But then, since you're in the front line of dealing with those kind of devolved issues, does it ever happen where you're given instructions to draft legislation and then you have to remind your client that actually that's a devolved issue and we might not have the competence to do that? Does that ever happen?
So we would always have the competence, because the UK Parliament has the competence to legislate for the whole of the UK. But there would always be a question about whether they wish to do that, and generally under the arrangements they will be speaking to the Scottish Government, and sometimes, or the Welsh Government or the Northern Ireland Executive, and sometimes they will want them to legislate in that area for them, because it might be simpler. They might not have a bill ready to go. It might be easier having one single regime. But sometimes it does happen, but it's more likely to have already been picked up in the department, because the department will know what's devolved and what's reserved, and so they will be advising their clients, and they will know which side of the line. And one of the things to always think about is even if it is devolved, but it's always worth having a conversation to make sure that they might want you to legislate for them. You might be willing to do that. So you might as well have that conversation rather than think, oh well, it's devolved, so we'll just sort of ignore that and carry on and doing our own thing, when we could actually have collaborated and joined up, which it depends on the policy area, obviously, whether that's going to be appropriate or not.
Okay, so then I wanted to ask you, moving on from the devolved issues and kind of onto international topics, is there any kind of a network that's comparable with the European judicial training network or something, where drafters from different jurisdictions would get together and discuss best practices?
Yeah, so there are various organisations, but the one that we have most involvement with is the Commonwealth Association of Legislative Counsel, because the Commonwealth drafting offices have a lot in common. A lot of them are set up on the same basis, not all. Some are now in the parliaments and operate in different ways, and that organisation is quite active. So they have regular journals, newsletters. They have a biannual, every other year they have a big conference where drafters from all over the world get together. That's been in London before, and that's a great opportunity to meet drafters from every jurisdiction and talk about approaches. And that definitely pushes us on as well, because we hear about things going on in other jurisdictions and we bring them back and try them out, or talk, have a longer discussion with that jurisdiction about how something is operating, and might we do that here too. So we've picked up ideas from other jurisdictions as a result of that. We've also, because of connections we make through that organisation from time to time, all of the offices I think in the UK have had drafters on secondment for periods. So we've had people from New Zealand and from Australia. I've had drafters out in New Zealand and Australia. So that's a good sort of cross-fertilisation and sort of seeing how different people do things. So I think the Australians were streets ahead of the UK in terms of trying to use plain English, as they would call it, and gender neutral drafting and all things that are absolutely standard now. But they were way ahead, and the UK at that time were sort of lagging along behind. But I think now there's such a vast, such an ability to share information now, that all those things get shared so much more quickly, that I think probably we're all, certainly all of the big offices are in a much more similar place on some of that thing. But it is interesting to look at statutes produced elsewhere, because I remember going to the first conference and one of the drafters from India getting up and talking about his government's legislative programme, and it could have been my government's legislative programme. I mean, almost every single bill was on the programme for our government. So across the world, people are grappling with the same issues at the same time. So whether it's bidding for telecoms licenses or social welfare or whatever it is, it's amazing how similar the problems are. And we have drafters. We had drafter visitors from Namibia last year, and we've had drafters from Kenya and other African countries. And again, they're grappling with just the same issues. And the day that we produced our original coronavirus regulations, I had an email from the drafter in Namibia who was doing their coronavirus regulations, and we were just comparing notes as to what the UK had done and what they were being asked to do in Namibia. So it's a lot easier to share that information now than it's ever been, and it's really interesting. And drafters are the same the world over. I don't know if academics are the same the world over, but if you meet a bunch of drafters from anywhere, they have a lot in common. So they enjoy getting together and comparing notes.
And are there any kind of common issues that come up in those periods where there's sort of really intense legislative activity? Like I imagine now with the coronavirus, Brexit, this is one of those periods. Are there any common issues that come up and how you deal with those to legal consistency?
Well, certainly Yes, I mean, coronavirus within, that has been a big issue. The regulations, of course, are secondary legislation, so they're not drafted primarily in my office. They're mostly done by government lawyers in the departments, or we have what's called a statute instrument hub now in the UK, where we have almost a sort of replication of the Parliamentary Counsel office of SI drafters, and they produce about 30% of the statute instruments across government. So I think our focus has primarily been, within that community, talking about the issues that have arisen. But in fact, we're just about to have an event with the Commonwealth Association of Legislative Counsel, where they have for some time been picking up the legislation being produced in different areas, and they've got an area on their website where you can go and see the legislation produced by the different jurisdictions and just sort of compare and contrast. And we're just about to have an event where we're going to be sharing some of the kind of issues that have arisen over that, and some of the ways that we've tackled it, and some of the the legislation that's been required as a result of coronavirus. So that's it's certainly an issue that everybody's been grappling with right across all of those offices.
Okay, so then I only have a couple more questions that I wanted to ask, kind of, I suppose, easy ones. One of them is about the issue of repeal. So we're teaching as part of constitutional law right now the issue of implied repeal and parliamentary sovereignty to our students. And you'd said about the repeal instruments that go into the Finance Act. Is it the norm now that legislation will include sections repealing earlier legislation, or is implied repeal still used? And if it is used, why is it used?
So I think the norm is that we would try and identify all the repeals, and sometimes we will provide delegated power in the bill if we think it hasn't, and there hasn't actually been time to. It's not just repeals; it's consequential amendments as well. So across the statute book, so say you're, I don't know, changing the name of a body, or introducing a new, replacing one body with another body, and everywhere that original body was mentioned, you need to put in the name of the new body. Inevitably, it's not as easy as just having a sort of block repeal that says everywhere you see this, read that, because you have to go into every single one of those provisions and make sure that's actually going to produce the right results. Because say it's about preserving the public record, you actually want to continue to preserve the public record of the old body and add the new body in. Whereas in another case, if it's conferring functions, if you've abolished the old body, then you want to get rid of the reference to the old body and put a reference to the new body in. So you need to be going through and looking at all those, and sometimes you just don't have time to do that. So sometimes you might confer in the instrument, in the bill, a power to come along and do that work later when the thing's going to be commenced. So we will aim to have covered it off either expressly in the bill or in terms of a power. But there are some things that you do where it's not actually really possible to identify everything that's repealed by saying subsection 3, this word here, that word there. So sometimes that might just be have to be read as implyingly repealing something that went before. I'm trying to think of something off the top of my head. But if you produced some sort of generic new provision that just sat across the top of everything, you might not go in and pick off everything underneath, because you might just say, well, it's clearly obvious that this is now the law, and therefore that other thing has to be read in a more curtailed way than previously, because this thing is sitting on top of it. Because it comes with parliamentary supremacy, that it's the last word of Parliament that you have to interpret. And what did that last word mean? Well, clearly Parliament must have intended to impliedly repeal some aspect of this thing over here, which is no longer consistent with it. But it would be fairly unusual. I mean, I think because of the way the statute book, going back to this approach of textual amendment, because a lot of our bills where we're operating on previous law are going in and actually textually amending that previous law, for the editor, it is actually much more useful if he or she can produce the consolidated text, and if we have set out every single amendment that needs to be made, whether it's a repeal or a textual amendment, and that's what we're aiming to do.
I remember
one of the challenges for us. Sorry.
No, go ahead. Sorry.
One of the challenges for us is that textual amendment approach is so unhelpful for parliamentarians, because all they get in their bill is a list of the amendments and trying to understand what the actual effect of that is. And so one of the challenges for us and for government more widely is making sure that we have other material which helps parliamentarians understand what those textual amendments and repeals amount to, because, you know, looking on the face of it, it's pretty incomprehensible.
Okay. So what I was going to say, I didn't realize I was interrupting you, but I was remembering back to the Constitutional Reform Act 2005 and the reference to the Lord Chancellor in the legislation as one particularly egregious example, where I remember reading that something like 900 pieces of legislation had to be changed just because that one person's role was referred to in those acts.
Yeah, no, that's quite possible. You know, when you do a search across the statute book, you know, for some term, and you might get, yes, loads and loads of hits, and you know, it's not so bad when it's you know, maybe a title, because quite often most of them will be pretty obvious what you're going to do. But if you're doing something like, so I did the legislation for the new licensing regime when it was brought in, and we took the licensing regimes. I think there were 8 existing licensing regimes, everything from dancing to cinemas to whatever, as well as alcohol, and we put them all together into a single regime. And then you had to go across the statute book and look at every single reference, however expressed, to something being licensed, and decide what you were going to replace it with. And so, yes, you can have pages and pages of consequential amendments, which is why sometimes you just run out of time to be sure that you've got them all, and you protect yourself by conferring a power to make sure that any that you don't spot get picked up later.
Is that something also that's happening now with Brexit legislation, where any of those implemented legislation would give references to regulatory agencies and stuff like that specifically?
Well, so in UA, with the original Withdrawal Act, so that has a power to basically achieve. The policy was for to have continuity of the law, but obviously a lot of the law that we were bringing in the European statute book that applies here, and we were basically dumping it in the UK on the end of the transition period now. And in order to do that, a lot of that doesn't quite work in a UK context. So it's got references, say, to the Commission or to member states, which previously included the UK and now won't include the UK. And so there are powers there to go in and fix that legislation so that it will operate in the UK. So that's what there have been hundreds of instruments that have gone through over the last couple of years to do all that fixing of that statute book to make it operate going forward. And that was incredibly technical drafting and sort of, you know, pernickety fiddly stuff that the instrument drafters were doing on that. Yeah, that was a big task.
I can imagine. So I just have one more question then to ask you, and it's kind of like a light finisher upper kind of a question. And it's something that one of the big differences that non-UK law students would observe when they look at legislation is that our legislation doesn't have preambles, whereas a lot of all EU legislation will, international treaties will. Is there any reason for that?
So our legislation used to have preambles. You know, if you look at very old statutes, they had preambles. I think many private bills still have preambles, and occasionally what we call hybrid bills, which are bills like the bill to set out the arrangements for big infrastructure projects like High Speed 2 or things like that. Those sorts of things. I think more recently maybe they haven't had preambles, but initially they would have had preambles. So, you know, the reason for a preamble, you know, set out the sort of reasons for having the bill and the effects of the bill effectively. Whereas we would say just read the bill, you know. So it sets up a competitive narrative of the bill to the bill itself, and so it's akin to a purpose clause. So we were often under pressure to include purpose clauses in bills, and you know, generally they're not a good idea. And that's not to say they're not ever a good idea. Sometimes they are a good idea. Sometimes you have a clear purpose to a bill, And it's helpful to set out that purpose and then interpret everything that follows in line with that purpose. But I can give you an example. So just before devolution, we worked on legislation that was improving the status of the Welsh language. So it's a long time ago. And everybody was very keen that this bill should have as its purpose the giving of equal status to English and Welsh. And they all thought it was marvellous. So it was motherhood and apple pie, really, because who could possibly disagree with that? The problem was that that wasn't what the bill did. The bill gave very limited status to Welsh in very limited circumstances. So if you have a purpose or a preamble which says this is a marvellous bill equating the languages of English and Welsh, and then you have a bill which doesn't do that, what does a court do? What does a court do when somebody challenges a provision because it doesn't give equal status to English and Welsh? Does it say, oh, well, you must have meant to give equal status, so we're going to read it as if it didn't say what it says, but it means something different? So, having those two texts competing doesn't seem to us to be terribly helpful. On other occasions, that will always produce the right result if you can come up with a clear purpose. But for big bills, it's actually very difficult to come up with a succinct purpose that actually accurately encompasses everything in the bill and would produce the right result. And so we will always be testing any suggestion that a bill should have a purpose. And I think that's in large part why we've given up on preambles. And I can think of an example when I was doing some work giving effect to an EU directive, and there was a provision in the preamble that just wasn't even represented in the statute, in the rest of the articles, and querying with the lawyer as to how this could be, and should I be following the preamble or should I actually be following the text? And they basically said, oh, it had been done very late at night and the text had been been changed at a last minute, and nobody had gone back and read the enormous preamble. And so some provisions were in there that weren't actually reflected in the text. Well, I don't think that's very helpful. So yeah, so we wouldn't want to go back to that. That's not to say that sort of setting the context of the bill is not helpful. I mean, hopefully the bill tells its own story, and a lot of our effort is put into creating an appropriate structure for the bill so that it does tell that story in a coherent way that somebody can pick it up and read it and understand it. But it can also be supplemented by the explanatory notes, which can set the context and the background and what you're trying to achieve in the bill. But we just don't think that material should be part of the statute itself.
And who drafts the explanatory note?
So the explanatory notes are drafted by the policy department and cleared by the lawyers in the policy department. And Parliamentary Counsel may be asked to input to check things or to confirm particular provisions, but they're primarily the responsibility of the policy department who are running the bill.
Okay, wow. Well, that was really, really interesting, and I have no doubt that our students are going to find that whole discussion very, very useful. I just want to say thank you so much for joining us today and giving us some of your really valuable time.